Can you really take it back? We're diving deep into the legal art of revoking an offer. When is it possible? When is it just too late? And what are the exact rules you absolutely have to follow? Let's get into it.
Oh, you've totally been there, right? You hit send on that email, you raise the paddle at the auction, maybe you even hand in your resignation. And then, boom, that sinking feeling in your stomach. That moment of, oh no, can I please undo that? That is exactly what we're going to break down today. So the official legal term for this is revocation. And look, it's not just about changing your mind. It is the formal, official act of pulling an offer off the table. And as you're about to see, the timing of this withdrawal, well, it's literally everything. So where is that line in the sand? You know, that exact moment when your offer goes from being something you can take back to something that is completely set in stone. We're going to call it the point of no return.
It all boils down to this one simple golden rule. An offer all by itself is just a proposal. It's just an idea floating out there. But the second it gets a valid acceptance, bam, it instantly transforms into a legally binding contract. And at that exact moment, your window to revoke has just slammed shut for good.
This timeline lays it out perfectly. You have this very specific, very critical window of opportunity. It's the time between when you make the offer and when the other person actually communicates that they accept it. That is your revocation zone. Once you get that yes, that opportunity is gone.
I absolutely love this quote because it just captures the explosive finality of acceptance so well. Think about it. The offer is the train of gunpowder, just sitting there, waiting. But acceptance, that's the lit match. And once it makes contact, the reaction is immediate, it's irreversible, and a brand new contract is born from that explosion. Okay, so let's say you're still inside that window of opportunity. How do you actually do it? How do you revoke the offer? Well, the law gives you a pretty clear toolkit. Let's break down the 4 official ways you can make it happen. So according to Section 6 of the Indian Contract Act, these are your 4 main tools. You can give direct notice, just tell them it's off. You can let the time you specified run out. You can point to a condition that wasn't met, or, in much more serious circumstances, the offer is automatically revoked by death or insanity. All right, theory is one thing, but how does all this stuff actually play out in the messy real world? Let's dig into a couple of fascinating court cases that hinged entirely on these rules of revocation. Check out this situation. On July 9th, a Dr. Parmanand submits his resignation. That's his offer. Exactly 1 month later, he clearly has second thoughts and formally withdraws his resignation. But then, and this is the crazy part, 2 days after he took it back, the committee gets together and decides to accept his original resignation anyway. So this lands us right at the core legal question. Could the committee just ignore his withdrawal? Can you accept an offer that has already been taken off the table? And the court came back with a clear no. The whole case turned on this. A resignation is legally just an offer. And like any other offer, it can be revoked any time before it's officially accepted. Since Dr. Parmanand pulled his offer back on August 9th, there was literally nothing left for the committee to accept on the 11th. The offer was gone. Auctions are another fantastic real-world example. Every single bid is a fresh offer. And that dramatic fall of the auctioneer's hammer, that's the moment of acceptance. Right up until that hammer comes down, any bidder can get nervous and pull their bid back. But what happens when there's a penalty for backing out? This is where it gets tricky. In this case, a bidder pulled their offer, but they'd signed an agreement saying their security deposit would be forfeited if they did. So now you have a clash, the general right to revoke versus a specific penalty you agreed to. And the court said, yes, they can keep the money. Here's why. Your right to revoke an offer is a general rule, but it doesn't just erase another specific agreement you made about the consequences. Basically, these clauses are there for a reason, to make sure people don't just throw out bids without thinking. Okay, so now we're going to take a step away from face-to-face deals and enter the wild world of contracts made by mail. This is where the famous or infamous postal rule comes in. And trust me, it creates a pretty mind-bending paradox. So here's the deal with the postal rule in India. The very second that a letter of acceptance is dropped into a postbox, the person who made the original offer is now legally bound. They are locked into the contract, even though they have no idea that letter is on its way. But, and here is the paradox, while the person who made the offer is bound, the person who sent the acceptance isn't. This creates this wild scenario, which is basically a race against the mail. The person who mailed their acceptance can actually change their mind.
They can send a faster message, like a telegram, to revoke their own acceptance. And if that revocation gets there before the slow letter does, it's valid. The acceptance is canceled before it ever arrives. Now, this very unique rule really shines a spotlight on some major differences between how Indian contract law and English contract law handle these situations. Let's put them side by side to see what's different.
You can see two huge differences here. First, in India, the notice that an offer is being revoked has to come from the offeror directly or their agent. In England, it's a bit looser. If you hear from a totally reliable source that, say, the car you were offered was sold to someone else, that counts. The offer is dead. And second, the massive difference we just talked about, Indian law lets you have that race against the mail to revoke your own acceptance. English law says no way. Once that letter's in the postbox, it is final for everybody.
Okay, let's bring it all home. Here's your quick and dirty rulebook for revocation. Number 1, act fast. Timing is everything. You have to do it before acceptance. 2, be clear and use one of the 4 legal ways. 3, know the rules of the game. Using email versus snail mail can totally change the outcome. And finally, number 4, always read the fine print for any penalties you might have agreed to.
And all of this leaves us with one big question to chew on. These postal rules, they were designed for our world of horse-drawn carriages and telegrams. But in our world of instant messaging, emails, and read receipts, where an acceptance and a revocation can land in an inbox at the exact same second, are these 100-year-old principles still relevant? Is the race against the mail finally over?